Okay, hello everyone. Welcome to this session on access to judicial remedies that is facilitated by FIDH and Connect Us. My name is Eline Vronsky. I'm from the International Federation for Human Rights, and I will be moderating this session. First, I'd like to thank the Office of the High Commissioner and the Working Group on Business and Human Rights for offering the opportunity for us to facilitate this session on such an important issue. Before giving the floor to our panelists, just some points on logistics and how the session will go on. There is translation in all languages. Those who would like to take the floor after the panelists may sign up to a speakers list that is made available in the room at the Secretariat. We will try to keep the presentations short so that you have a chance to speak. In case you don't, we're very sorry for that, but we're running late already. We will have to stop at 6 p.m. sharp, but you can, of course, send your statements afterwards. And we will strive for a balanced representation of stakeholder groups in taking the statements. And finally, your statements should not be over 2 minutes. This being said, we have several speakers today on this Access to Justice panel. I just want to acknowledge the presence with us today of two affected stakeholders. I think it is if not the only one, at least one of the few sessions of this forum where affected stakeholders will have the opportunity to present their views. It is Rosa Amaro, who is coming from La Oroya in Peru, and DK Kunda, who is coming from the Democratic Republic of Congo. Before giving them the floor, I'd like to ask Juana Cueto, who is the Program Director of Connect Us, an international human rights organization based in Brazil, which works on human rights in the Global South, to give us an introduction into the topic. Thank you very much.
Okay. Buenas tardes a todos.
Good afternoon, everyone. First of all, I'd like to join in thanking the Office of the High Commissioner for the invitation extended to Connect Us to organize together with FIDH this particular session. Thank you all for coming, as the general public, and also for those who are involved in the overall debate. I'd like to welcome the speakers who are here to present their ideas. FID has worked with Connect Us to organize this seminar, working from some distance away. I'm Juana Cueta, and I'm here representing Connect Us, a human rights organization based in Brazil, aimed at strengthening human rights organizations in the Southern Hemisphere. I'll make a very brief presentation setting out the objectives of our session, and I'd like to cover three issues. One, the first, is what is the importance of the right to judicial remedy in human rights terms? The second, what is the level of development of the right to judicial remedy in terms of the guidelines, and also the future role of the group and other UN bodies in this respect. Let's turn to the first point now, the importance of the judicial remedy for human rights. As you're aware, there are a few issues that are so key to human rights procedures as the right to effective judicial remedy. As we heard this morning, the right to an effective judicial remedy involves a core issue for international human rights law. Then the next point is the difference between a benefit and a right. And that is precisely when you have a right, there's a question of whether or not one can have effective access to justice to ensure some form of reparations. It is important to make sure that there's access to a mechanism to halt violations and ensure responsibility and accountability. Treaty bodies and regional human rights mechanisms have developed tremendous jurisprudence focusing on the right effective remedy. There are detailed parameters as to how to ensure access to the remedy. These elements are key to the concept of judicial remedy, and in particular there's the concept of independence and impartiality of these remedies that need to be analyzed in the context of violations of human rights committed by enterprises. There's a question of independence, as I said, and impartiality of these remedies that we'll need to take up and analyze. Now, how has this concept been dealt with in the guiding principles? The guiding principles were innovative when it comes to dealing with non-judicial remedies, but they're inadequate when it comes to the right to an effective judicial remedy. The principle number 26 indicates that states should adopt measures to ensure the effectiveness of judicial mechanisms, but it doesn't really mention judicial remedy as a right. Subsequently, the commentary to Principle 26 sets out some of the obstacles to access to justice. For example, the structure of the entrepreneurial group, difficulties to bring legal action in country of origin of the company, discrimination, high cost of proceedings, difficulties in obtaining counsel, and difficulties in bringing collective action, lack of training for monitoring bodies. The guiding principles have thus identified the barriers, but they've provided very limited guidance for states as to how to overcome these problems, and they haven't mentioned obligations incumbent on enterprises. This morning, the High Commissioner mentioned that this third pillar of the guiding principles has not been sufficiently covered in recent debates, and that this is essential to ensure legitimacy and success of the principles. So this brings me to the third point. Looking towards the future, how can the working group contribute to resolve this question of the inadequacies in the principles regarding access to justice? The group clearly recognizes the importance of the issue, and for that reason it was included in the agenda of the forum. But it's important to note that the guiding principles are not the end point, but the starting point. Implementing the guiding principles when it comes to access to effective judicial remedy will require specifying its content in greater detail. The working group should use as a basis work already done by the treaty bodies and regional jurisprudence. This morning, the High Commissioner mentioned that the working group has a draft on effective judicial remedies, and it would be useful to draw on the opportunity we have today to look at this initiative. To specify the content of the right to effective judicial remedy in greater detail, the working group is of the view that we need to focus more on the victims, be closer to the realities, and make recommendations to the states and companies involved. And in this respect, Connectors, together with Amnesty International, urge the working group to interpret its mandate in accordance with work being done in other UN specialized bodies, and that should be done in its visits and in dealing with individual and collective cases. In the light of these points, the purpose of today's debate is to generate input to provide support for the work of the working group in filling in these gaps in providing effective judicial remedy. Thank you.
Thank you very much, Juana. I will now ask Rosa Amaro, who is coming from La Oroya in the central Andean region of Peru, a city that you might have heard of because of its high levels of contamination. Rosa Amaro represents the MOSAO, Movimiento para la Salud de La Oroya, the movement for the health of the people of La Oroya. Rosa is among the group of plaintiffs before the Inter-American Commission for Human Rights against Peru in this case. Rosa, the floor is yours.
Thank you. I've come from Oroya in Peru, and I'm here to speak on behalf of those who do not have a voice. There are 3,000 of us living in Oroya, and we have 8 communities. We're among the 10 most polluted communities in the world with toxic gases, lead, cadmium, etc. The levels of blood in of lead, the levels of lead in newborns, some 40 micrograms per deciliter of blood, and that exceeds the 10 accepted by the World Health Organization. In 1997, the smelter was bought by Doron Company, a North American firm, and it belongs to a single owner who is famous because they've never accepted responsibility for the pollution in all of the companies that they own. The sales contract had imposed certain requirements on the state and the company, DRC, Doron Company, and there was meant to be certain environmental work done within 10 years, but Doron Company has asked for several extensions and has failed to meet its environmental and labor commitments. The complaints regarding lead poisoning have now affected some 1,300 countries in Arroyo. Over some 10 years, DRC has used various judicial maneuvers to sidestep its responsibilities. There have been attempts to gain access to justice. In 2002, we filed a case against the state of Peru seeking protection for Oroya inhabitants, and the urgent measures agreed on by the Constitutional Court were not complied with. And then in 2006, as a result, we turned to the Inter-American Human Rights Commission for interim measures, and that was agreed on, but these were never fulfilled. In the United States, the Missouri court ordered DRC Doron Company to pay compensation for damage to the health of 170 children. This has never been paid. Doron Company DRC sued Peru for $800 million, claiming that legal obligations were not met in keeping with the smelter purchase contract, and that imposed responsibilities for the environment on both parts, and consequently payment for the compensation for children is suspended. Failure to obtain justice. Neither Doron Company nor the state has fulfilled their obligations, and that applies to the health of the people and payment of compensation for victims. Victims have not got justice, and we do not see how we can get justice. Attacks on Oroya defendants. My name is Rosa Amaro. I live in Oroya, Antigua, Old Arroyo, with all my family. Opposite the smelter, I have 38 micrograms per deciliter of lead in my blood, and my son has 58.3. I'm a member of Masao, which is an organization which was formed by persons affected by La Arroyo pollution. All of us as members of this group are victims. We've been slandered. We've had to face reprisals, death threats, and this applies to our relatives as well. I had a business, I lost it, and I had to leave Oroya because of the threats that I faced. I have come here to bring some proposals to see whether the United Nations can turn its eyes to the situation in Oroya. The United Nations should insist that Peru provides specialized medical care for persons so affected, and it should prevent transnationals that are irresponsible from operating if they fail to respect human rights. And they should insist on their accountability and that they regulate their operations properly. They should ensure the safety of those who report this situation and they need protection from acts of harassment. This needs to be done urgently as our health is getting worse and worse over time. In the group that has brought the case to the Inter-American Commission, 3 persons have already died. We're urging the United Nations to call on the enterprises to respect our rights and our right in particular to a healthy environment. Thank you.
Thank you, Rosa, for sharing this testimony. I think what we'd like to convene to the audience is there are several issues in this story, but maybe what we can retain for now is to see how certain companies resort to litigation strategies aiming not only at escaping liability, but also at closing the door to access to justice for victims. The second issue is what was also discussed this morning is how human rights defenders or affected stakeholders that are trying to seek justice are being repressed, sometimes criminalized, and at the very least threatened. Now I'd like to ask DK Kunda, who is coming from the Democratic Republic of Congo, to share his own story. DK's families have been hit by serious human rights violations during the events known as the Kilwa event. In October 2004, the company Anvil Mining, an Australian and Canadian company, provided vehicles, drivers, and logistical support to the Congolese army to assist in countering an attempt by a small group of rebels to enter the city of Kilwa, a port in the DRC key to the company's operations. During this operation, serious human rights violations were committed against the civilian population by the military. The vehicles of the company allegedly transported soldiers as well as civilians who were brought out of town and executed. According to the UN, around 100 people were killed during these events. And I would like to ask DK to explain how he was personally affected by these events and what they have done to seek justice in the Congo and elsewhere.
Well, I too would first like to thank the organizers for this opportunity to discuss issues. And so I am the son of Pierre Kunda Musapelo, who was a former police chief in Kilwa. My father died in 2009 following torture and harsh treatment inflicted on him by the Congolese military during and after his arbitrary arrest during the October 2004 events in Kilwa. My elder sister, Dorcas, 22 years old, died after having been raped by soldiers during the same operation. So the impact on our family was that my father and other people were arrested by soldiers during the operation. When I visited my father in Kazapa prison in Lubumbashi, that was where he had been transferred, he was unrecognizable. He'd lost a lot of weight and could hardly walk. He could hardly talk either. And the only thing he could tell us was to ask us to try to find food for him and to pray for his release. Only on the 15th of April 2005 did the military tribunal establish that my father was innocent of the charge of high treason. He died 4 years afterwards as a result of the torture and inhuman treatment inflicted on him while he was under arrest. His health was very delicate after his release, and he suffered from awful illnesses until he died. While he was in prison in Lubumbashi, I had to stop my studies in order to provide him with help. And once he died, my family found it difficult to eke out an existence because he was the sole breadwinner. Now, there was a trial in Kilwa. It was held in a military tribunal, and it was concluded on the 28th of June 2007. And what happened was that all those accused of war crimes in relation to the Kilwa events were acquitted. Not only were the 3 employees of Anvil Mining who were charged acquitted, but the actual company was acquitted. In fact, at the beginning of the trial, they weren't even on trial. The victims' families met a number of obstacles during the whole procedure. First of all, the Congolese authorities prevented the inquiries from taking place for almost a year. Witnesses and victims were intimidated. Members of the Human Rights Defense Team received anonymous death threats. They were told that they should stop their work on the Kilwa case. Serious pressure was brought to bear on so many witnesses and members of the victims' families not to testify. Anonymous assailants went to my parents' home in Lubumbashi to try to frighten them. The military prosecutor came under pressure to drop charges against the Anvil Mining employees. When he resisted the pressure, he was transferred. The court sought to discredit the evidence from victims and families and simply rejected appeals from all the plaintiffs. And now let's look at the fight for justice outside the country, outside the Democratic Republic of Congo. We had so many problems trying to get justice in the country, so we started proceedings outside the country. And so, as I say, since the Congolese system didn't do justice to the victims of the Kilwa events, we turned to the South African and Canadian governments, asking them to continue the investigations and to institute legal proceedings against their nationals who were referred to in the trial, and in the case of Australia and Canada, to take proceedings against Anvil Mining as a legal entity. In August 2007, the Australian Federal Police closed the investigation, which they'd opened in September 2005, acting on the orders of the Australian Foreign Ministry. And their investigation covered the role of Anvil Mining and Anvil Mining staff in the October 2004 events. In November 2010, in a court in Montreal, we submitted a request to authorize a class action against Anvil Mining Limited as a Canadian company. The representatives of the following NGOs, RAID, ACIDH, Global Witness, and the CCIJ, set up the Canadian Association Against Impunity in support of that class action. And they are represented by Trudel and Johnston in Montreal. In April 2011, the Higher Court accepted the appeal from victims, thus opening the door to a possible class action in Canada. So we had a bit of hope. But in January 2012, the Quebec Appeal Court rejected that, saying that a court in Quebec is not the appropriate forum to hear the case because the incident took place in the DRC in October 2004. And this was more than 6 months before the mining company opened its office in Montreal. Previously, the headquarters of Anvil Mining was in Perth, in Australia. And there too, we had tried to go to the courts without success. Just as in the DRC, where a military tribunal was just a sham process of justice, led to the acquittal of all the accused. In January 2012, Anvil Mining was bought out by Minmetal Resources for $1,300,000. That's a Chinese company which bought it out. So, what do we now seek? From the UN. Without the help of Anvil Mining, the soldiers could never have got to such an isolated town in such a short time. According to the UN mapping report, this case showed how difficult it is to prove the legal responsibility of private enterprise, even when they provide logistic support to armies. And we have no other choice than to turn to the international community to seek justice and put an end to impunity. Furthermore, we would like to see a mechanism to be set up within the UN to bring to justice those responsible for the most serious crimes, whether they be companies or states. Thank you.
Merci beaucoup, DK.
Thank you very much for that testimony, DK.
For this testimony on how the victims of the Kilwa case have tried to seek justice elsewhere and of the difficulties that you have encountered. I just wanted to tell you that material is available at the back of the room on these two cases, both on the human rights violations themselves as well as on the different proceedings that have been taking place. So please refer to the documents to have more information on the cases. I would now like to ask Antonio Escrivao, who works as a legal advisor at Terra de Direitos in Brazil, an organization who is particularly supporting landless peasants as well as urban communities victims of forced evictions to seek justice. Antonio will explain how multinational companies operating in Brazil tend to externalize certain activities and, as a result, escape liability. Antonio.
Okay, thank you. And first, I'd like to thank Connected and Feed for the invitation. Okay, externalizing risks is a pattern of avoidance from human rights violations liability in Brazil. It takes place when the transnational hires or even creates a small company for the execution of indirect activities where it takes place human rights violation. like security activities or environmental impact studies, for example. It's related to the principle number 26 in the guiding principles. What should necessarily be strengthened? In Brazil, this kind of pattern is usual concerning to business related to agribusiness that usually installs their activities in areas belonged or occupied by agrarian communities. I'll bring to the discussion two Brazilian cases where only the externalized companies were put into investigation to seek liability for human rights violations that clearly should be reached the other enterprise involved. The first case is about the murder of a landless worker at Syngenta's experimental field in the city of Cascavel, state of Paraná, in Brazil, in the year of 2007. The second case is the construction of a port of Cargill at Tapajós River at Santarém, state of Pará, in the heart of the Amazon rainforest. Well, the first case took place in an experimental field of this major producer of pesticides and genetically modified seeds in the year of 2007. In this year, one of its fields was occupied by Via Campesina, a social movement, as a denunciation against the impact of and disregard to the environmental legislation related to its activities of the company. In response to the action of this social movement, the security company hired by the transnational organized a real war counterattack operation, becoming to kill this leadership named Keno and seriously injuring another one, a woman, shot at close quarters after its surrenders. It happens that in the civil lawsuits that seeks the company's liability and compensation for the damage caused to the victims and its families, only the security company has been held responsible, while, on the other hand, the transnational claims alleging that it has no responsibility for the occurred in order to have been accomplished by the hired company. It turns out that this security company was being investigated by the Brazilian Federal Police at the time that occurred this murder, because of a suspicion about its connection to a landless killing militia that acted in the state of Paraná between the years of 1998 and 27. A notorious fact at the time because of the murder of 5 landless workers in distinct episodes. This notorious fact shows at least that the hiring and so the murdering could have been avoided from the beginning. In the second case, about the construction of the port in Tapajós River, we like to say that under Brazilian law, the construction of great works must be preceded by environmental impact studies to be conducted to establish the viability of the installation, the size of the social environment impact, and the resulting mitigation measures that should be supported by the benefit company. In the case of the installation of this port in Santarém, Tapajós River, that was constructed to flow and export soybeans that is advancing over the Amazon rainforest. Well, this port was installed without an environmental impact study, with full connivance of the government. Due to social pressure, however, the transnational was demanded to submit the impact studies, and to do so hired a company to conduct the study and prepare the report. After the studies, the report resulted in the conclusion that the port at Tapajós River had not generated any impact. Obviously, this was questioned by civil society and affected communities, forcing the public prosecution on demanding accountability through an investigation founded on the suspicions of fraud against the report of the environmental impact. It turns out that the public prosecution of Pará state demanded on justice only the hired company and mentions nothing about the transnational. In fact, with the report, the port was given to the port was given a license without any mitigation measures or duty at all. Well, here the question is, companies should not be held liable for the actions of its contracts when hiring companies that violates human rights on the job for which it were hired. To this question, we are seeking to strict liability and joint liability. A good example to be brought in the mechanism, to be brought here, is the mechanism of the Protocol of Nagoya Kuala Lumpur in the ambit of the UN Biodiversity Convention that brings joint liability to the exporting country in case of GM contamination and damage, what should be brought to the business and human rights scenario. Finally, it's important to say that the reparation and liability of these hired companies is not enough to inhibit or prevent human rights violation. In fact, this way of reaching these externalized companies finds to be a manner to sustain a business culture of human rights violations. Thank you very much.
Thank you, Antonio. And I think we will have the opportunity to discuss how complex or even direct business relationship render access to justice even more difficult in many scenarios. Now I'd like to ask Katie Gallagher, who is a senior attorney at the Center for Constitutional Rights, to look at practical and legal obstacles in seeking redress through extraterritorial jurisdiction. Katie has been engaged in litigation in the United States against multinational companies and private military contractors in particular in connection with torture in Abu Ghraib. Katie Gallagher recently wrote 3 amicus briefs to the US Supreme Court on the Kiobel case, and she will try to outline a number of obstacles but also of opportunities in the United States on this issue.
Thank you. Thank you very much to the organizers for having me on this panel. And it really is quite an honor to be speaking in this room where there has been so much debate, discussion, and development of human rights standards. But it's really a particular honor to speak on this panel with Rosa and DK and to remember why we're having this discussion in the first place. So as Eileen mentioned, I will try and provide a very brief survey of some of the legal and practical barriers to seeking a remedy in domestic courts for egregious human rights violations. And then I will move on to what are some of the outcomes of this litigation and what we need now to really give effect to Pillar 3 of the guiding principles. Some of the legal barriers we've already heard mentioned in the 2 cases that DK and Rosa spoke about. We have legal doctrines that are invoked in essentially every case we bring against a multinational corporation for serious violations of international law, whether in the United States under the Alien Tort Statute, whether in the United Kingdom using domestic tort law. In Canada, we heard about the challenge there. And there is a lot of litigation going on in domestic courts all around the world, whether it's using domestic tort law, whether it's using specialized statutes. There is indeed a lot happening, but it is very challenging work. Among the legal doctrines that are most often invoked by multinational corporations are forum nonconvenience, essentially saying that there is a better forum that should be hearing this case, like the case against Anvil, why is this case being heard in Canada? Shouldn't this case be heard somewhere else? Well, as we heard, the DRC, Australia, other venues were not available. So you can invoke a forum nonconvenience argument, but then you're essentially left, in many cases, with no forum. Immunities. This is an issue I faced in litigating against private military contractors in particular. Corporations that are hired often to provide security services, hired by governments. They try to invoke immunity of the state to themselves, as even though they're non-state actors, and would be bound by contract law to be held accountable for any contract violation. But this is a big challenge that we often face in litigation. Happily, in our case on behalf of torture victims from Abu Ghraib, we have made it through this particular challenge and will be going to trial soon in Virginia under the Alien Tort Statute for war crimes and torture. So while it's been a challenge in one case, we made it through in another. Exhaustion of domestic remedies. Again, this is a question that multinational corporations who have themselves presence in many countries will say, well, why are you bringing this case in the United States? In the case of Arroyo, why aren't you bringing this in Peru? So again, the plaintiffs are left going from forum to forum, showing that a forum may not have either a safe venue or one that will provide appropriate remedies. Political question doctrine. This is something we saw particularly in the previous decade being invoked in cases. On behalf of states, or even the states themselves, they were coming in to say that litigating against a corporation can impact their foreign policy preferences. So they were pitting foreign development, economic development, against human rights. And all too often we saw states preferencing economic policies over human rights policies. In terms of some of the practical or logistical challenges, to litigate across countries, it's quite expensive. This is not easy litigation to bring. You have to have lawyers, experts, plaintiffs traveling literally back and forth across the globe sometimes, and litigating against corporations which have very deep pockets. It is often law school clinics with nonprofit organizations who are engaging in this litigation. So you have to be very selective and very limited in the number of cases you bring. Security costs. For those activists, for those members of affected communities who are willing to speak out, first in protest maybe, or in opposition to a corporate plan, to then actually engage in litigation, it brings an amount of personal risk. And this is something as a lawyer, as a plaintiff, you must factor into any decision to actually engage in litigation. Finding a lawyer. We have a pro bono culture in the US, and we have this Alien Tort Statute that we've been using. So you do have a small group of lawyers who engage in this kind of litigation, but it still is a very specialized field, and we don't have enough lawyers who are engaged in this process. Because of conflict of interests, many of the big law firms cannot and do not get involved in this litigation because it could block them from taking on business with maybe the extractive industry or the private military contractor industry. So that is a challenge. And then finding a lawyer when you're a member of an affected community, very, very far away. I'm speaking too long, so I'll move quickly through. So once you overcome these challenges, you still face some very large questions. And in the last couple of years in the United States, in this Alien Tort Statute litigation that we do, we've had questions of the most fundamental nature that have arisen. Questions of whether corporations can be held liable when they are complicit, aiding and abetting human rights violations. That debate seems to have come down on the side of yes, they can. We've had now before the U.S. Supreme Court 2 huge questions, fundamental questions, whether corporations can be held liable at all for egregious human rights violations. This is the issue before the court in Kiobel, the case against Royal Dutch Petroleum for crimes against humanity committed in the Niger Delta. The Supreme Court added a second question to that case, and that's whether you can have extraterritorial jurisdiction, meaning if the egregious human rights violations occur in Nigeria against a foreign company with foreign plaintiffs, should this case be heard in the United States? You don't even need all 3 foreign. They're actually saying just for acts that occur outside the U.S. And this is an issue definitely not specific to the U.S. It is a debate that is playing out in many countries. So it's interesting when we look at the evolution of CSR. In some ways, I think that the litigation against corporations has fed the CSR movement. I would call it the corporate accountability movement. It's certainly fueled the debate. It's brought questions to the fore. Most importantly, it's given voice to many victims and their stories that otherwise wouldn't have been heard. But I do think it's interesting that almost 20 years into litigation in U.S. courts against corporations for egregious violations, we're seeing company after company line up on the side of questioning whether or not corporations can even be held liable in the first place. So whether we're moving forward or moving back, I think that's very much an open question. Thank you.
Thank you very much, Katie. And I think we will certainly have some discussion about whether further development of standards is needed, in particular with regard to the most serious crimes. And Professor Ruggie this morning outlined that an intergovernmental process might be needed. And, well, I hope we can have a discussion after this panel on this. I'd like now to ask our 2 last panelists to give some concluding remarks. We will start with Gabriela Quijano, who is a legal advisor in the Business and Human Rights team at Amnesty International. And as you know, Amnesty International has been working these last years and months, in particular, looking at obstacles faced by victims to access justice.
First of all, I wanted to thank the organizers very much for inviting me to participate in this panel, and Juan and Eileen, obviously, in particular. And I also wanted to thank Rosa and DK for coming all the way to Geneva and sharing their experiences with us. I think this panel so far has been excellent in a number of respects. The first key point to make is that, as Juana framed the issues under the international human right to a remedy. So we often forget that what we're talking about here is a human right in itself. Remedy is a human right in and of itself. And also the central role of judicial remedy in the international human rights regime. Then there was an excellent mapping of barriers, typical and recurrent barriers to justice in cases of corporate human rights abuses. We have done extensive research on cases across the Americas and Asia and Africa, and we confirmed that all those barriers that have been referred to today are typical and are recurrent. And also we wanted to emphasize a number of other obstacles that haven't been referred to so far, but that we have found that are particularly problematic. One of them is not often described as an obstacle to remedy, but this is the curtailing, impairing the right to remedy through shaping the regulatory regimes under which a corporation will operate, sometimes even before a corporation sets foot in the country. So often by negotiations that take place behind closed doors, companies are able to extract certain concessions or benefits or limit their liability for certain harms. And that's before even nothing has gone wrong yet, but the right to remedy has already been affected. And what happens is that when then something does go wrong, the victims find themselves without the legal tools that they would have normally have had, and they weren't even aware of this. The lack of access to information is another key issue that is not often described as an obstacle to remedy, but it is, because often communities don't even know that they are suffering a form of harm. Their waters might be contaminated, but they're not aware of this. They might know that there's some form of damage occurring, but they don't know the extent, its depth, its nature. They might not know who's causing them harm, who to claim against, who's responsible of certain decisions. And when they want to take a case to court, they struggle to find the relevant information and evidence, and this means that often they don't have such a strong claim, legal claim to make. Often, of course, this information is in the hands of the corporate defendant itself, so the challenges are obvious. The problem of the separate legal personality between different members of a corporate group, and in particular a parent company with regards to a subsidiary, it's something that's been spoken about very vastly, but it is a real issue. And the separate legal personality, that means that the liabilities of a subsidiary company are not automatically attributed to a parent company. This exists even when the parent company is the full owner, it's a majority owner, and even when in practice they have total control over the operations of a subsidiary company, or over aspects that were behind the abuses that took place. I wanted to refer also to forum non-convenience, although it's been touched upon, but what I wanted to refer to is that in our research we have found that often when a case is rejected on forum non-convenience, in theory then the claimants can then go back home and initiate a case at home, but this hardly ever happens. By this time, years have taken place litigating the forum non-convenience issue in itself. Resources may have dried up, and the spirits are very low, and it is hardly ever the case that they do then initiate a case at home. The Omai gold mine case of Guyana is a very emblematic case in this respect. So now I wanted to refer back to implementation of the UN guiding principles and refer to what we consider should be the focus in the years to come. So it's been said already, much greater emphasis must be placed on Pillar 3 and on the duty of states to ensure effective remedy, and this is both of host states and home states, especially judicial remedy. A crucial step in this direction is to remove barriers to justice. I don't think that a lot more can be said about barriers. It's been years now we've been discussing barriers. What are the typical barriers to justice? We need to move to removing those barriers. We have often found, and it's been concerning, that in discussions on obstacles to remedy, the proposition has been made, either overtly or implicitly, that because there are so many obstacles and these are so insurmountable, then we should look elsewhere and should look at other alternative means of redress that are often of less quality and less protective of human rights, and ideally, if working well, the courts are. So the state duty to provide effective remedy entails a duty to remove barriers, and also it entails not taking regressive measures. And I'm thinking specifically about the UK recently passed law, the Legal Aid, Sentencing and Punishing of Offenders Bill, that removed some arrangements that were possible so that these claims in the UK against UK companies were financially viable. That's no longer possible, and obviously as a consequence, these cases are more challenging than they were before. And also the regressive interpretations advanced by the UK, by the Netherlands, and recently by the US in terms of applicability of the scope of applicability of ADCA, the Alien Torts Claim Act, in extraterritorial litigation. So I wanted to make a quick connection to link to Pillar 2, which is another area of much discussion during this forum. And so the responsibility of companies to respect human rights. In our view, the effective implementation of Pillar 2 will be driven to a considerable extent by the real prospect of successful legal claims against companies in courts. But this incentive today doesn't exist. So Pillar 3 is not just about guaranteeing access to remedy, it's about also ensuring that companies comply with their responsibility to respect human rights. So therefore, it is also about preventing human rights abuses. So what we would like to call on governments and decision makers and the working group is to place much more emphasis on Pillar 3 and to move into concrete initiatives to implement, to guarantee access to judicial remedy. And just very quickly, and I know I've been given 2 minutes, but I wanted to refer and to call the attention of the working group to a number of areas that they should start exploring to address some of the obstacles that I've referred to. In terms of the shaping of the regulatory environments, we feel that much greater emphasis must be put in transparency and mandatory disclosure of information regarding negotiations and agreements between governments and companies, and in particular, negotiations on legal reforms and legal frameworks that will apply to companies. They should be open in the public, and the communities affected need to know about them and have a say in what legal reforms have been proposed, and not only find out about them when they have realized their rights have been taken away from them. On access to information, mandatory disclosure of certain key information that should be non-negotiable, the detail of corporate structures, environmental, social and human rights impact assessments, and the company's plans to address those identified impacts, risk management plans, whatever they're called, they need to also be put out in the public domain. Tools to address some of these issues are more effective freedom of information legislation, but then there is a need to look at the scope of this legislation to also ensure that they extend to information held by private actors when this is relevant for the effective protection of rights, improve procedural rules on discovery. On parent and subsidiary liability issues, we claim that companies should be placed under an express duty to prevent human rights abuses or a duty of care towards individuals and communities whose human rights are affected by the activities of the subsidiaries or entities that they have an ability to control, and that this duty of care should be defined by reference to a human rights due diligence process that is genuinely focused on the prevention of human rights abuses and implemented in a robust, transparent and participatory manner. And the last suggestion is on jurisdiction and forum non-convenience. We have found that often in the decision-making process on the most convenient forum, what is lacking is a much more prominent focus on human rights and the right of access to justice in particular. And these issues should figure much more prominently and should be preliminary and overriding factors in a court's assessment of the most convenient forum. And this goes down to the issues that have been referred to today in the two testimonies that we heard. It's not just about the mere aptitude of the courts to hear a case. It's looking at the broader context and the extent to which the claimants stand a realistic chance to access remedy in their home countries. And with that, I'll close. Thank you very much.
Thank you, Gabby, for getting us back to the guiding principles and for making the link between Pillar 1, 2, and 3. I just wanted to flag an instrument that hasn't been mentioned yet, but I think is relevant here, is the Maastricht Principles on the extraterritorial obligations of states in the field of economic, social, and cultural rights. It is a document adopted last year by a group of experts in human rights, and we believe that this document is a good guidance for states to see how to discharge their obligation to protect in relation to human rights violations committed by companies or involving companies that are incorporated into their jurisdiction but happening elsewhere. Before giving the floor to our last panelist, I just want to remind you that the list for speakers is still open, but will be closing soon. So please, if you want to ask question, make you known to the Secretariat. Our final speaker is Laurel Bellows. She is a business lawyer in Chicago and the president of the American Bar Association, an association which gathers 400,000 lawyers in the United States. She has been active on business and human rights issues, in particular through her work against human trafficking, and she will be giving the closing word before we hand over to Michael Addo if he wants to make comments. Thank you. Laurel, the floor is yours.
Well, thank you very much for the opportunity to join you here today at this extraordinary panel, and thank you to those of you who gave both passionate presentations and set forth for us the realities that we are just simply talking about, but living the realities. And then a particular thanks to my co-ending closing speaker, Gabriela, for being very specific about some of the remedies that are available, which is a lot of what we need to talk about. I would like to just indicate that the American Bar Association works in and has members in over 90 countries. So you think of us as the American Bar Association, but we have been actively engaged in the protection of human rights and the rule of law initiatives throughout the world. And we don't have just lawyer members. So our 400,000 are non-lawyers, and we want to make certain that you spread that word, because it's important to us that the entire human rights community feels comfortable in joining with us and guiding us so that we can learn from each other in this seemingly impossible but very, very crucial fight. Let me indicate that there are 5 themes of particular relevance. I'll just skip the introductory remarks and go right to some meat and some comments. First of all, the need to reinforce the remedy pillar. I agree with Gabriela, and I think it's important that this is a message of international awareness that effective judicial remedies are, in fact, a human right in themselves. And I say that because, not only because it's true, certainly, but because we all know and say that the availability of judicial remedies, especially for the vulnerable individuals in our communities, is what we really have to address here, because that is the gap. The concern is that we don't have any meaningful way under the parameters that we have, that we address, that are the tools that we have been given up to this moment, to actually solve the problem of lack of access. In fact, it's important for me to convey to you that I believe things are getting worse, certainly not better, and not only because of the difficult economic times in which we find ourselves, but because of bad habits. So when the American Bar Association travels to assist to remedy a destroyed judicial system post-conflict, for instance, in Sierra Leone or Liberia or in many other places, we find that one of the first questions we need to ask is, what is the access to justice, but what are the resources with which to bring back a justice system into a torn economy and country? And we find that it's almost impossible in bankrupt states that are trying to rehabilitate an entire society to find money for a justice system, because we have medical, we have to feed people, we have to even take a look at the imperative of confirming property rights, we have to talk about medical care, we have and housing, so many things, and justice in these communities and development nations seems to be perhaps not the very last item, but so far down the list that as a priority that it becomes totally not affordable. My bad news is that in the United States today, that is the case. The same arguments that I am hearing as the courts in Los Angeles, California, are closing. We have just closed 200 courts in the United States, in Los Angeles alone. In my city of Chicago, and realize that that's the city of our president, Barack Obama, we are closing our federal court 1 day a week. That's 20% of the time. We have courts throughout our country that are not hearing civil cases For a year, they have decided that in order to have sufficient access to the courts for our criminal cases, which are mandated to be heard within a short period of time, that they are unable to hear civil cases. Imagine what that means for an entrepreneur who needs to pay her employees and has to solve a contract dispute, which is a civil issue. So now what I'm saying to you is that we are arguing in our state legislatures, where funding is given for our state justice systems, the same argument that I needed to make in Liberia or Sierra Leone. And that is that justice system is crucial to a democracy. But in our democracies, all right, which are extraordinarily fragile, we are spoiled and not really identifying the fact that even in the most developed countries, the judicial system is at risk. The judicial system is at risk everywhere. And if I leave you with any thought today, these are not just words. So what is probably the greatest barrier to access to justice? It's not simply money. It is that we haven't coordinated a fight worldwide with one voice. We have many voices, but not worldwide, with a single voice, that it isn't a single country's problem. It is, as I say, either a bad habit or the plotted recognition that if you want to do away with democracy, you destroy a judicial system first. Now, everybody in this room understands that, but I don't think that we understand it at this level into many of the countries that are represented here. So I cry out to you today to talk to each other in addition about the specific remedies, and I have a few other suggestions, but my message from hearing what's happening here is this is a crisis of unimaginable proportions unless we come together with a single voice, using the same words in many languages, but using the same words. That a judicial system is imperative and it should be a priority, perhaps after feeding our children and assuring medical care. But without a judicial system, we are not going to function in any case. So we might as well just go home, go under our beds, and not come out. So adequate resources are not a significant enough word for that. The other problem that I think that we've mentioned, but not quite at the level that I would like to leave us to issues or to solutions perhaps, is of course that we must protect those who are protecting us, and that is the Legal Defenders Program that the American Bar Association is so engaged in and so many of you are supporting. We have to support the lawyers who are risking their lives in countries all over the world to lobby and take the judicial cases forward with their life at risk. And that's something that we also can come together on with a single voice. Because when a lawyer is at risk, it's not simply, it is all of us and all our energies are at risk, where if we come together, it is a message we can deliver together. The last is a judicial remedy that we have in the United States and is used elsewhere, but is crucial. Penalties for violation of human rights are insufficient. So in the United States, when we have penalties for civil violations, we use what we call, we have the civil jury, all right, which we're holding on to by the skin of our teeth, but that civil jury also provides us with punitive penalties, monetary penalties that have the capability of putting the perpetrator of wrong out of business completely, bankrupting, denying that perpetrator's family of a livelihood, taking away that perpetrator's home, perhaps, right? Making them understand that more is at risk than a couple of years in jail, and perhaps not. So I suggest that we look at not only criminal penalty, but civil financial remedy. That part of our law that is not seen favorably in most countries in this world at the moment is actually a tremendous vehicle for offense because offense is what we need to take in defense of our civil liberties and our human rights. And then, of course, we wait anxiously together for the verdict of our Supreme Court in Ciobo versus Royal Dutch Petroleum to see exactly what might be available on the jurisdictional question and then determine a course of action. And there again, I would say that whatever is the result, that course of action needs to be joint. And so at the end of this, as I thank all of you for coming together with your very, very cogent suggestions and specific ideas, that this crisis that we face, that it grows only by the minute, needs us in concerted action. At the same time, we need to act locally. And that is why this convening, Michael, is so tremendously important, because it gives us an opportunity to not just meet and greet, all right, but become determined once again to speak with a single voice at the same time we go home and work our magic in our homes and locally. But that single voice, I would emphasize to the working group, is something that we have not identified, and a single voice with a single message that we could hear on radio, we could hear in the print, we could hear everywhere, all right, not just on computers, because we all don't have computers, but a single voice on some form of satellite radio that talks about solution. Thank you.
Thank you very much, Laurel. This also takes us to the deterrent aspect of justice, and if things are clear and you know what you risk, then maybe human rights abuses would be prevented in the future, and I think this is a point we have to bear in mind when we're discussing access to justice. I have a list of speakers that have asked for the floor. Maybe before giving these people the floor, I would ask Michael Addo, a member of the UN Working Group, if he'd like to comment on what he just heard.
Well, Ellen, on behalf of the Working Group, I'd like to thank you especially for moderating this event, but also to thank the panelists for their very inspiring contributions. I think listening to the presentations, I suspect there's nobody in the House who's not been moved by some of the evidence that's been presented. And certainly this will hit, well, I said hit me, it will hit the Working Group very hard. It certainly gives me the idea of how difficult the task is and how important it is for us to pay attention to Pillar 3. Now, the guiding principles do provide excellent opportunities, particularly what I call the two fates, or what has often been referred to as a smart mix of the guiding principles, because normally Pillar 3 has this preventive side and this remedy after prevention has failed. And so the idea of how you sort of deal with something when it has failed actually becomes a particularly difficult instance, as you can see. But the future, of course, is not so gloomy, because we do have opportunities, certainly in the mandate of the Working Group and in the strategy of the Working Group, in trying to develop connections in what we call embedding the guiding principles in governance institutions. There was a reference to consider links with the judicial, international judicial mechanisms like the Inter-American Court and the European Court. These are very, very useful suggestions which the Working Group will take on board. I do also take the idea of the fact that this is the only instance in the mandate of the Working Group where we have an opportunity to make further recommendations to the Human Rights Council. Listening to the testimonies and the presentations and the recommendations does give us a good, solid, evidence-based platform to make recommendations to the Human Rights Council for future development of the guiding principles. And this being the one area where I think we have that opportunity, I think we propose to take it forward to the Human Rights Council. So we do need that kind of support. I think I'll leave my comments at this moment and sort of follow it up if necessary.
Ms. Adela Parra from the state of Colombia has asked for the floor.
Buenas tardes.
Good afternoon. The state of Colombia at present has set out its public policy in the National Development Plan and has two broad guidelines for human rights. One is building public policy in human rights and international humanitarian law, and secondly, having a human rights and international humanitarian law system that involves institutions, standard setting, and policy documents. With this two-pronged approach, as regards business and human rights, we have the challenge of ensuring effectiveness of judicial remedies and ensure that due action is taken in case of corruption. Right now, we're building our public policy, and in so doing, we've identified one key aspect in respect of human rights. One is the penal or criminal aspect. In this area, we're working inter alia on strengthening or ensuring greater penalties for illegal mining offenses, recognizing that when it comes to business and human rights, the question of mining is one of the major hazards that as a state we need to monitor and also make sure we have the necessary measures as regards the criminal aspects of this and how to deal with these offenses. We have noted that we need to take action in other areas to protect human rights, and this includes action or people-based action such as class action when it comes to criminal action, and this ranges from the judicial level to provide for protection of collective rights or rights that have been affected and which apply to a group of persons. So to speak specifically about group actions protecting collective rights, we see that in business and human rights, the right to a healthy environment is linked to free competition and consumer or user rights. In addition to that, when it comes to group action, it's important to ensure remedies and compensation for consumers as a whole, and this applies to environmental rights and other rights such as anti-monopoly rights. All these actions, penal and non-penal, are a challenge that we're now working on in the context of our human rights policy, particularly business and human rights policy.
Mr. Batesmith.
Yes, hello, good afternoon, everybody. My name is Alex Batesmith. I am a former war crimes prosecutor with the United Nations. Have worked previously in Kosovo and Cambodia. I've got one question and I've got one request. My question is, what does the panel believe the impact of the soft law of the guiding principles will be, and the business and human rights movement, of which this forum is of course a shining example, on domestic prosecutions of human rights and international prosecutions of human rights? That's my question, and my request is, could the working group propose to the Human Rights Council to request the extension of the International Criminal Court's jurisdiction to include companies as legal persons, as currently it's limited to national persons? Thank you.
Okay. Mr. Amaru from the Indian movement.
Gracias, señora presidenta.
Thank you, Madam Chairperson. Tupac Amaru would like to ask the chairperson of the forum, Business and Human Rights, whether this mechanism set up by the Human Rights Council has a mandate to receive and process and deal with all complaints from victims that is of transnational enterprises. That's one key point. We'd like to know exactly what your mandate is. Secondly, Tupac Amaru has always in this forum and in this room for some 20 years been speaking out in defense of indigenous peoples and denouncing the crimes of transnational corporations from Western countries. We have often published written statements. The latest one deals with the Asangaro Peru Declaration on pollution of water, and this was caused by Canadian mines. We've worked a lot to ensure that there's an instrument that is binding and which regulates the activities of transnational corporations. Why have we done this? Simply because, well, as states and indigenous peoples and all peoples, I'd like us to bear in mind that today's world, this virtual world, is dominated by 100 major transnational corporations and 50 infinitely huge financial institutions that decide the fate of mankind. To quote this in order of precedence, 90% of the main huge transnational corporations have their headquarters in the TRAD. That is the European Union, 53 corporations, United States of America, 26, Japan, 18. And in developing countries, you just have Cemex, a Mexican cement company, which is among the 100 huge corporations. And we've seen that all these businesses work on the basis of profits, earnings. They're not interested in human rights or human dignity. By that I mean that human rights and maximizing the value of capital are incompatible concepts. You can't reconcile the movement of capital of multinationals with human rights. Here, we've been talking about this for some 20, even 30 years, and the issue has not been resolved. Why? Because there is no political will on the part of the Western countries that I just mentioned. They come here to talk about human rights, but they fail to see that their multinationals are violating human rights in Congo, Peru, Bolivia, and everywhere. Having said this, I would wind up by saying the following. If we do not have a binding, mandatory international instrument for transnational corporations and states, this forum will be nothing but a show. And I'm saying this because 25 NGOs have written a letter rejecting the competence of this forum because we will be falling into the same dilemma.
Leave the floor for other people to speak. Thank you. I'd like to ask Mr. Matthias Klott from the Council of Europe.
Yes, thank you very much to all panelists for their very interesting presentations, in particular those who shared their personal and very moving experiences with us, participants of the forum. I would just quickly like to add that the Council of Europe as an intergovernmental organization and with its probably most well-known organ, the European Court of Human Rights, is very interesting interested in the topic and attempting to contribute to filling the implementation gap of the UN Guiding Principle at the European level in a complementary manner, also with the European Union, bearing in mind that our organization has 20 member states more than the member states in the European Union. Last week, our steering committee for human rights, which is comprised of representatives of all member states, has adopted a study on human rights in business, which will be then submitted to the Council's main decision-making body, the Committee of Ministers for further action. The study contains proposals for a strategy on the subject, notably through the facilitation of the implementation of the guiding principles through awareness-raising measures or possible instruments to be adopted in the future, such as recommendations. I'm saying this in this panel because a particular emphasis has been put on the third pillar of the UN guiding principles, and in the course of this exercise to look at access to justice for victims of corporate human rights abuses, some of the questions and existing barriers that the panels have mentioned may be addressed. Thank you very much.
Thank you. Carlos Cordero de Sustenta.
Gracias.
Thank you. I'd like to thank the panel, which is one of the most interesting ones that I've seen. And what I'd like is for the panelists to tell us more about the dilemma. Well, not really a dilemma, but perhaps the approaches to remedying the whole problem of access to real justice for victims. Would it be better to work on a powerful international instrument through the UN system and the International Criminal Court, as just mentioned? Or should one think more in terms of influencing through pillar number 1, this duty of states to protect, and the approach of the competence of courts of justice would need to look more into the aspect of the principle of universal justice for human rights violators in the case of the business sector. Thank you.
Okay. Next is the Women Initiative for Transparency and Social Justice from Nigeria, Mrs. Spiff.
I'd like to look at the access to judicial remedy from the context of Nigeria and Africa in general. We are usually met with a lot of barriers, such as funding for the communities and also the long years of trials that communities had to go through, or the judiciary had to put them through for them to have remedy. And I want to ask the working committee and also the panelists, to see how they could remedy this. For instance, I had a case with Saipem Oil Company in Nigeria on my human rights abuse. Even as a CSO or a woman activist, the case has taken more than 6 years for me to have judgment up to today. It happened in 2006, and till today, I've not gotten my judgment. I also want to make a suggestion to the working committee concerning the way we can move forward on the judicial remedy in terms of engaging the judges in Africa. Most of them don't even understand what the voluntary principle is all about, because before I came for this forum, I tried to talk to one of the judges in Rivers State, in Niger Delta, that I'm going for a UN forum on human rights and business. He said, what do I mean by GP? What is GP? And this is a very senior judge, a justice in Rivers State. So he's one of the judges, and if he does not know what GP means a lot of them in Africa there don't even know what it means. And for us to, for us to fast track the implementation of the remedies, judicial remedies in the GP, we should, as a matter of fact, engage judges in African countries so that when cases of human rights abuses from communities come to them, they will not delay justice. They'll be able to do it fast and get the communities get remedies for the communities that are concerned, because it's usually said justice delayed is justice denied, and also to encourage communities to speak up when such things happen, also to encourage communities to seek for judicial remedy, because if they are being delayed, they won't see any reason of going to the judiciary for any remedy. They will rather go to war, fight companies, to get jungle justice themselves than going through the judicial process for justice. Thank you very much.
Thank you. We still have 3 speakers on the list, so we'll take the 3 of them, but please be short so that the panel has some opportunity to address at least the questions. Next one is Richard Howitt from the European Parliament.
Good afternoon. And at the European level, John Ruggie came to the presidency conference organised by Sweden in 2008, asked the European Union to work on extraterritorial jurisdiction, and we still haven't responded. And so I want to accept self-criticism about that. I do come from a country, the United Kingdom, where there have been a number of cases brought using extraterritorial jurisdiction to what is now called the Supreme Court. Particularly, I pay credit to a firm of solicitors called Lee Day for doing that, but changes to the rules on legal aid in the UK is going to block off those opportunities, which I deeply regret. The 2 questions that I have for the panel: firstly, it does seem to me that in America there's a lot of case law, but we're struggling to find case law elsewhere. It's minimal in Europe. And I think that in terms of being able to win the argument to make it easier to bring cases, we need to find a good test case whereby not just the merits of the case are good, which is of course important, but that the general applicability of the case to show the need for extraterritorial jurisdiction can be established by the visibility and awareness raising we could do around such a case. Does anyone on the panel want to comment in relation to whether such a case might be in the offing that could come before the court somewhere in the European Union? And of course I put that question with a large number of other people in the room listening. And my second question to the panel is this: John Ruggie this morning made a very clear call, similar to the one that he made in 2008 and since, but this morning he said that he wanted an intergovernmental process to bring clarity to the issue of extraterritorial jurisdiction. Could members of the panel suggest who, how and where government should best get together in order to take that suggestion forward?
Thank you. Our next speaker is Sok Leng from the Cambodian Center for Human Rights.
Thank you. Thank you for the opportunity. First of all, I'd like to express my appreciations to the courage made by our friends, DKs, Rosas, and then I would like to also express that we have a lot of support and always support to you. And because in Cambodia such cases and example are a lot also, and then I believe that everyone knows about what happens, and this is just a few example. And you know, in Cambodia, just add another story just very quickly, is that in terms of what happened in our testimony today, it happens in Cambodia. And another case that I would like to raise here is that for example, in Cambodia, in government sectors, textile sectors, recently, in order to maintain a job, in order to keep a job, some women have to force themselves to get to do the abortions when they are pregnant. in order to keep a job which give them like less than $100 salary. And in this case, in the times that, for example, in Europe, that we need a population growth. In Cambodia also we need population growth. But the serious thing is that in order to keep a job, we need to get aborted. So this is very serious. Okay, the second thing I would like to raise is it happens in indigenous people. In Cambodia, someone mentions earlier that the place where the belong to indigenous people are resource rich, and then it's also culture rich. So if we just let businesses to do business and then they just violate human rights, they just clear land, they just chase people out, force people out, not only they violate human rights, and I believe that or we are together trying to get rid of these indigenous cultures that we have the mandate. Actually, the UN has a mandate to preserve, but it is on the rise that these kinds of cultures of indigenous people is on the decline with the rise of business on those areas. My third point is about the court. Basically, in many of the cases, when we say it is about human rights violation, local courts say it is a criminal case. And when there are problems within this jurisdiction of human rights, usually the local court that are not independent, in many countries that are not independent, and then business people are very good at turning this case into a criminal case. So victims will even be victimized, and then they are imprisoned because of their their defense of their human rights. So I think this is a very serious, and I would like to appeal for these kinds of considerations and attentions into making sure that the case that are dealt with, which we call as human rights cases, should be human rights cases related, not to turn attention to criminal cases where the friends of the government and the business always wins because they know how to do it to win the case. Finally, for the homesteads, I think now when in the country in a country where the courts are not independent, when courts are not independent, and then it's very difficult to get them to comply with all these GP. But the homestead has very, very important role to play in order to put pressures on the companies and the businesses. And my very last question, the only one question, is that whether if this case happen when the homestead don't do anything, when knowing that the companies has done something or has been involved in human right violation, can we consider this is complicity as well? Thank you.
Thank you very much. I think the translators are finishing in a couple of minutes. I just propose that we give the panelists a chance to reply to the questions that were put there. So I guess we'll continue without translation if needed. May I suggest, Michael, that you start with the questions that were directly to the working group regarding its mandate in particular?
Thank you very much. I think a number of questions are directed to the working group. All some of them were recommendations, and I think we welcome the suggestions and recommendations very much, particularly the idea of engaging with judges in Nigeria. I think that's an excellent suggestion, and we'll certainly follow that up. There were two very specific questions directed to the working group. One on what we think our mandate is concerning individual communications. I'd like to say that the scope of our mandate is a matter of public record in Resolution 17.4, and to the best of our understanding, we will receive information as part of the mandate in the process of gathering evidence of good practice. So by all means, evidence or any information, any communication, it's very, very welcome. And the question had a second side in terms of processing. And in the light of time, I should say we have considered this and have issued a statement on the manner in which we will process such information. And I think we put a copy of that on our website, but I can let you have a hard copy on that. So I think we've confronted this subject and we'll deal with it. There was a second question, and I wasn't quite sure whether the question was meant to be whether we will recommend to the Human Rights Council on the question of the extent of liability for corporations under the ICC, or whether we can. Now, whether we will depends upon the evidence that we can gather and make it focused and structured to the Human Rights Council. Whether we can, of course, if the evidence allows us, yes, we will be able to, we can be able to recommend it. So, of course, a lot depends upon gathering the information on the ground. Okay, I think those answered my questions.
Okay, maybe before giving the floor to the other panelists, for the sake of translation, I think Rosa wanted to say a final word.
As a Peruvian, I'd like to insist that we, as people dealing with these issues of pollution, well, if the state of Peru had had the standards in place to insist that transnational corporations fulfill all their social responsibilities, then we wouldn't have had perhaps to be here bringing cases, lawsuits. However, sales contracts for corporations and the concessions extended to transnationals, especially in the mining industry, the contracts and the arrangements made in the free trade treaties, I believe that these documents too need to be revised, because one cannot just think about investments. You have to think about the consequences that these involve if you don't have the regulations and the standards to protect our people, to protect all of our population. I think that's what we should aim at by way of a conclusion to deal with the problems that we're facing right now. Thank you.
Very much. I suggest we continue the row. Katie, on.
There's a lot I would want to comment on, but I'll try and just make one comment tying together the pillar one. Should we look at national courts, a binding international instrument, and the ICC? I don't see any of this as a choice of one versus the other. Obviously, all three in many ways feed each other. We see, because of the ICC ratification, states now enacting criminal responsibility for corporations that didn't have that in 1998 when the question first came up, where you had much more of a debate of common law, civil law systems, can we have corporations held criminally liable? So there has been an evolution already due to the ICC on the domestic level. As the domestic cases are playing out, and I believe there are many, far more than just in the US, it really depends on how you examine the cases. If you're looking for a violation of international law versus looking for a domestic tort that reflects egregious conduct, thinking broadly about environmental claims, there is actually a lot of development on the national level. And that development, depending on how far it goes or where we hit roadblocks like we've discussed today, that will give guidance to whether or not a multinational, whether an international instrument is needed. My caution there would be that we will have that instrument largely defined by states. And if states are failing to take down some of the barriers to national litigation, I'm not sure we're going to necessarily love what we see on the international level. So I think there's a continual interplay between all of these three issues. I think where we could use some clear guidance is strong statements, whether it's from the working group, on where these doctrines simply should not be permitted to block access to justice. If we have some strong statements there, it will open up the fora, whether it's domestically or internationally.
Thank you very much. Juana?
Okay. Gracias.
Thank you. First of all, I'd like to thank you all for the questions and the comments that we've had in this really fruitful discussion. I must say that I'm really pleased that we moved away from mapping the obstacles to see how to go about removing these obstacles. And this will no doubt be one of the key roles of the working group, bring forward innovative and creative ideas as to how obstacles to access to justice can be done. There's been successful experiences in Brazil with what is known as a dirty list. Through key cases coming to the courts, a list of companies has been built up that have been directly accused of carrying out unfair labor practices. They can't get credit from the bank, and there are other privileges that are not available to them. And that's how good interaction between access to justice and other measures that ensure that the law prevails is dealt with, such as avoiding slave labor of this type. And these are ideas that could be replicated. I'd like to draw attention to what was mentioned in terms of access to information as a component of access to justice. It's hard to proceed without adequate information, most of which is held by the companies. In March, there's the interpreters are now leaving. Apologies.
Ámbito en el cual precisaremos trabajar un poco más. Algo que se me ocurrió durante la discusión es tal vez pensar en la revisión periódica universal, pedir. Okay, I have to try to switch to English. Okay, in the UPR process, maybe we should ask directly state to announce which barriers they have been able to remove. Put it as a point, not politics of promotion of the guiding principle, but concrete measures to remove obstacles. And on the call for intergovernmental discussions on extraterritorial jurisdiction, I think as any process at the UN, we will need some states that lead the discussion, probably an open-ended group. But we are very lucky because in this case, we already have a document. Eileen mentioned the Maastricht principles. So we have an initial document to start the discussions. We need states, and I hope until the end of the forum, we will have the name of the states that will be promoting this debate. Thank you.
So then the final word will be for Gabriela.
Okay, thank you. I don't remember all the questions, but I thought of addressing at least three things very, very briefly. One question was from Carlos Cordero about the dilemma between the need for an international instrument that provides some avenues for redress and whether the attention should be placed on national level courts. And I think, like Katie said, they're not mutually exclusive. I think both need to be addressed and explored. But the one thing that I would like to say is that if it was about expanding the mandate of the ICC, we are still talking about a reduced number of international crimes, and if it's about an international system of redress that addresses larger abuses, that would still be a limited number of cases that would make it all the way. So I think it would be incredibly important, and we've seen in the regional systems that acts as an incredible catalyst for improvement at national level. But again, we have to continue emphasizing national level courts and home state courts. There are many, many, many more courts, and there could possibly be at the international level, that have the ability and should be providing immediate, effective redress to victims in host states and in home states. So that would be my thought. In terms of soft law mechanisms and the impact this would have in courts, I'm not a litigator, so that would be probably better answered by some of the acting litigators, but we would want to think that, yes, that would be the case. We would want to push, and have done in a couple of cases, where we have actually brought in the international developments in soft law mechanisms on due diligence that need to have a bearing on the interpretation of duty of care, for instance, of companies in cases brought to courts. These are important, widely recognized standards at the international level that need to have a bearing on how courts interpret the duties of companies in specific cases of human rights abuses. And in terms of access to courts in the EU, and again, I'm not a litigator in the EU, but we have done quite a lot of inquiries with lawyers in some EU jurisdictions, and my understanding from those inquiries is that the fact that there aren't that many cases in the EU, at least 3 factors have been raised with us that are key for why more cases are not brought in. One of them is the financial arrangements. There are no viable financial incentives or arrangements so that these cases are viable in the EU, such as they used to be in the UK, and the US is more attractive in that sense. It makes it easier for claimants to bring cases and not have to pay massive costs up front, or they have some more flexible arrangements with lawyers that make these cases viable. The other issue is evidentiary rules as well. We've seen in the case in the Netherlands against Shell that there's been major issues about the evidentiary rules and trying to have access to some key evidence in the hands of the corporate defendant, and this is not properly addressed in many civil law systems that are typical of the EU, not so in the UK and the USA. And the other one is that there is no culture of legal within the legal community of taking these cases and taking on these major cases, as much as there is now to a certain extent in the UK and in the USA. So those are 3 factors that have been brought to our attention of why there are more cases at EU level. Thank you.
Thank you very much. I guess we could be discussing this issue still for another hour or day or week, so I suggest that we close here for today. I think there's a lot of food for thought for ourselves, but also for the working group who has a lot on its plate. I would like to extend a big thank to the panelists, in particular to our friends from the DRC. DK, thank you for being with us and for traveling to give your testimony. Gracias, Rosa, for being here with us. We sincerely hope that you will get access to some remedy, and that will be an effective remedy, and we are really supporting you in that fight. Thank you also to the other panelists. You've been really great in bringing all different issues for our consideration, and thank you for the participants for staying over. And finally, I'd like to thank the Office of the High Commissioner for providing this opportunity to us to present our views on this subject. Thank you very much.